The Law Factor with advocate Clarence Arenas Gandawa.
In a land shaped by tradition yet governed by law, where do we draw the line, and who draws it? This is the story of power, principle, and the silent clash between custom and constitution. Welcome to The Law Factor. Over to you, Advocate.
Thank you, Stella. Greetings to you all. The Constitution versus custom. Who governs the last word? In every society, the law must answer difficult questions. But in Eswatini, those questions often come from two directions. One written in the Constitution and one inherited through custom. Both systems carry legal weight. Both shape people's lives. But when they disagree, when a customary practice contradicts constitutional guarantees, who decides what is lawful? This episode of The Law Factor explores that tension, not to create conflict, but to offer clarity. So, understanding constitutional supremacy. We begin with the foundation of modern legal systems, which is constitutional supremacy. In Eswatini, the 2005 Constitution is the highest law. It establishes fundamental rights, equality, access to justice, freedom of belief, and protection from discrimination. These rights apply to all citizens, regardless of gender, age, or background. Yet, alongside this constitution, operates a second framework, customary law. Often unwritten, it governs marriage, succession, land use, and traditional leadership. It is cultural law, deeply respected, historically rooted, and still widely practiced. The Constitution recognizes it, but sets clear limits. Customary law may not violate constitutional rights. Let's start by identifying where the boundaries play. The real challenge arises when constitutional rights and customary norms pull in opposite directions. For example, what happens when a woman is denied inheritance because tradition favors male heirs? Or when a marriage, valid in custom, offers no legal protection under civil law? Here, the courts play a critical role. They must interpret the Constitution with wisdom and assess whether the custom in question respects or violates legal rights. This requires careful review and deep understanding. Let's move to judicial review and legal pluralism. If a customary court issues a decision that violates constitutional rights, that decision may be challenged. But not every citizen knows they have that right. Nor are all judges trained in navigating the space where tradition and statute. This is where judicial review becomes vital. It allows superior courts to correct misalignments and create legal coherence. To do this well, our judiciary must be equipped to understand legal pluralism, the interaction between customary law and formal law. Now, let's talk jurisdiction and access to justice. Most cases rooted in custom, marriage disputes, land issues, succession disagreements, begin in traditional courts. But when these rulings are problematic, can citizens appeal? Do they know how? Does the system make that process accessible? For many rural communities, navigating the legal ladder from custom to constitutional review is unclear. Strengthening access to justice means clarifying jurisdictions, improving legal pathways, and ensuring citizens know their rights. Then we explore the role of Parliament. Parliament has the responsibility to update laws that are outdated or incomplete. Customary marriages often lack the legal protections of civil unions, especially for women and children. Succession laws may still favor male heirs despite constitutional guarantees of equality. Rather than rejecting custom, legislative reform must build alignment. Custom can continue, but only where it respects the rule of law. And now to empowering the public through legal literacy. Law is not just for lawyers and judges, it's for everyone. Citizens must understand when custom is legally enforceable and when the Constitution provides them with protection. This requires public education. Through schools, media, chiefs' councils, churches, and civic platforms, legal literacy must become a national priority. Let's use Eswatini as a case study for the continent. Eswatini's legal journey is not unique. Across Africa, countries face similar tensions: constitutional reform alongside living custom. From Kenya to Botswana, Ghana to Malawi, the question is the same. How do we honor culture while upholding rights? Eswatini offers us a mirror, and that reflection invites reform. So now, as a final advisory note, I say, the Constitution offers structure, custom offers identity. But when identity denies justice, structure must intervene. Let courts adjudicate with clarity. Let Parliament legislate with purpose. Let citizens learn with confidence. And let all legal systems, customary and statutory, move towards harmony. The law does not erase identity, it protects it. But only when we know its reach, its power, and its promise. The law moves forward, you must move with it. See you next Thursday.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.